by Victoria Aguilar, the founder and managing partner of the AR Group, a law and HR consulting firm headquartered in Greenwood Village, Colorado. They deliver affordable services uniquely designed to add value to both large corporations and emerging companies. Victoria is a seasoned lawyer and has spent nearly 20 years providing legal services to Fortune 500 companies. She's also certified as a senior professional of human resources. Victoria, if you're ready, I will hand it over to you.
I am. Thank you so much for that introduction. Okay, well, welcome everyone to this webinar. We've been planning this one for a while, and I suspect that we're having pretty solid attendance because at least most, if not all of you, have probably heard about the upcoming changes to the Fair Labor Standards Act, which is going to have a fairly profound impact on pretty much every business in the country. So with that, I'm going to go ahead and launch into an overview of what we're going to be covering today in this webinar regarding FLSA changes that are anticipated here effective December 2nd. Before we get into that, just to give you a roadmap of where we're going to be going today, in terms of an overview, we're basically going to provide you with a little bit of background on the Fair Labor Standards Act itself. As we go through this webinar, you will often hear me refer to the Fair Labor Standards Act as the FLSA. I try not to speak too much in HR speak, but sometimes when you're dealing with employment law, it's an alphabet soup of acronyms. So if you hear me reference FLSA, I'm really just hearkening back to the Fair Labor Standards Act, which is the subject of this webinar. The governing body over the FLSA is the Department of Labor. It's important, and we'll be kind of trying to take some moments as we go through here to remind everyone that the FLSA is a federal statute, and it's governed by the United States Department of Labor. And so it's the Department of Labor that issued this new rule that is, frankly, a seismic shift in how we as small businesses and large businesses alike will be needing to contemplate how we categorize our employees as either exempt or non-exempt. One thing that I really want everyone to recognize, because I know that this is a national audience, is that in addition to the FLSA, the Fair Labor Standards Act, which is governed by the United States Department of Labor, every state in the union also has its version of a Department of Labor, though many of them are called by different things. And pretty much every state in the union also has an analog to the Fair Labor Standards Act. As already mentioned, I'm in Colorado. I'm licensed to practice law in a number of jurisdictions, but I'm physically located in Colorado. And we here in Colorado have an analog to the Fair Labor Standards Act, and it actually is provides more protection to employees in our state. So for example, in Colorado, when we're talking about this new rule and whether or not overtime compensation is to be awarded to a certain group of people, unlike the Fair Labor Standards Act on the federal level, which only says that employees are entitled to overtime compensation for hours worked in excess of 40, in Colorado we have the added opportunity for overtime for all hours worked in excess of 12. With the exception of certain defined employee classifications such as nursing or something like that. So I will caution everyone as we go through this, we're really focusing on the federal level, and everything when I'm referencing the Department of Labor is the U.S. Department of Labor, not necessarily talking about how this is going to, or how your state laws are going to affect what we're going to have to deal with at the federal level. So finally, we're going to talk about the potential impacts, and they are fairly enormous. Even the Department of Labor recognizes the impact to be tremendous, but regardless, they're coming our way. And then we'll talk about moving forward strategies. There are different options. Unfortunately, it's going to require a fair amount of heavy lifting from most businesses in order to figure out what option works best for you. Ultimately, running away from the reality of the situation is probably not the best option, but believe me, I've been practicing law long enough to know that some people will choose that option. Moving on, in terms of the background, I just want to kind of tick through some of this because I think it's important. How we work with our clients is really to kind of help them understand kind of how we got to some of these laws. Most of us as business owners, which I am too, you know, get a little frustrated with the heavy overlay of regulatory construct on us as employers. And while I certainly am sympathetic and empathetic to that, it's oftentimes, I think, helpful in terms of managing your enterprise on a going forward basis to at least have an understanding as to why we have to deal with this stuff. So with respect to the FLSA, it harkens back way back to 1938, and it was adopted in a post-Depression era time. Why? You know, this is the time of Reconstruction. Everyone was trying to, you know, get people back to work, and in order to promote concepts of equanimity and fairness in wages, this act was seen as a good step forward to ensure that the country was really going to grow on the basis of a fair wage. And so this act was born with this sort of philosophy that, you know, all boats rise when we don't allow anyone to earn too little, so that everyone's family life can maintain a minimum standard of living in our country. So the Fair Labor Standards Act was built around these principles, and in order to achieve those principles, those lofty goals, we established for the first time in our country a minimum wage. Together with that, we also established overtime compensation because, you know, the idea being that we shouldn't be, as employers, allowed to basically work people to their bone and still just pay them a minimum wage. If they work extra hard or are being forced to work too many hours, they're entitled to a kind of an additive wage. Obviously, child labor prior to this time was also something of an issue, and so this act took it upon itself to really resolve that problem. And for the first time also, we as employers were required to keep records in terms of compensation to our employees, and we needed to be able to substantiate that. And that record-keeping aspect is going to come back, you know, big and bad in terms of the context of the changes that we're going to experience effective December 2nd. So coverage at this time applied to all employees, and there were really kind of two types of employer coverage, and individual coverage and the enterprise coverage level. So then we have the FLSA overtime requirements, and this again is the original act, the context of the original act. So this is where we started talking about non-exempt employees and how that differs from an exempt employee, and that exempt employees were not entitled to overtime compensation, but non-exempt employees were. And so this act really started to kind of put the structure in place for what overtime compensation should look like. And in general, overtime compensation was set at 1.5 times the base rate of pay. So if your person earns $10 an hour, their overtime compensation needs to be set at $15 an hour in general, because there are definitely some exceptions to that depending on if you have discretionary bonuses and things like that, which we'll talk about as well later. Again, and this is kind of my way of highlighting for all of you guys, remember that your state may have a different construct. I know, for example, in California, it also has a requirement in addition to overtime compensation being eligible for more than 40 hours in a week, which would be consistent with the FLSA. And also, like Colorado has an eligibility for overtime for hours worked in excess of 12 in a day. California also has for any day of the week in which someone works more than 8 hours, they're entitled to overtime compensation. So, you know, it's really important for everyone to really understand application in your jurisdiction. So the purpose of this, and again, these are in support of lofty goals, right? The idea behind the statute is to put financial pressure on employers so that employment is more broadly based, whereas before this statute, there was a fair amount of employers who were just kind of sticking to a limited workforce and just kind of working them really hard, and that wasn't good for the country as a whole, because you have fewer people employed and thus more poverty. And the idea here was this act would force us into a more fair and equally based approach to employment of individuals. And obviously, attendant with that would be, you know, that the opportunity for us to abuse our workers was decreased significantly, because now we have more people working more sane hours. So the whole idea of exemptions, and I work a lot. My law firm is dedicated, you know, really, with the exception of about 25% of our revenue coming from federal government contracts, you know, the rest of our revenue is really focused. We market exclusively to the small business marketplace, by which we define as employers with fewer than, you know, 200 to 300 employees. So we focus on this market, and what I have found in my years of practice is that too few of us as business owners are really even necessarily truly aware of what it means to be exempt from the FLSA. And so the exemption, as originally devised, were created around a number of categories, and the ones that are most salient for our purposes today, because there are more than just the white-collar exemptions, but we're going to focus on those for the sake of this conversation, because they are the most common by far. But the white-collar exemptions were designed to apply to a predetermined fixed salary. So what it's basically saying is that there are white-collar exemptions, but to qualify for that sort of exemption, one has to receive a fixed salary, by which it means that if I work 40 hours in 1 week and 35 hours in the next week, I still get the same amount of compensation because it's a fixed salary. Similarly, as we've grown accustomed to in today's marketplace, you know, as a exempt level professional, you generally work at least 40 hours a work week, and it's not really a question of working less than that. It's more often a question of, well, I work 60 hours, but do I get compensated for 60 hours of pay? And the answer is no, because I qualify as a white-collar exempt individual. The other aspect to determining whether or not there's a white-collar exemption at play is that the amount of salary must meet a specified minimum, okay? And the specified minimum is part of what we're here to talk about, because that minimum is going to increase dramatically. At this time, though, the statute put in place these elements to protect against people abusing the idea of what an exemption should look like. And then finally, the statute dictated that there should be a job duties test, and that the job duties test will help to put up the framework around what actually is an exempt level individual in terms of their work product or their job description. Historically, the Act has applied for a very long time, applied 2 different tests, and there's obvious philosophies behind these 2 different tests. There was the long test and there was the short test. And the long test was designed to, you could have a lower minimum specified salary requirement under the long test if you had detailed requirements for duties, and if there was a limit on the amount of non-exempt work that the employee could perform, which in general came to mean approximately 20% of work was limited to non-exempt type of work. So at some level, even at the inception of the statute, it was recognized that not all of us always, you know, day in and day out do nothing but exempt level work. So the statute was, you know, building in an understanding of the possibility that some positions are somewhat hybrid. Then there was the shorter test. The shorter test really was basically if you had a higher minimum specified salary requirement, then, you know, they were going to, the department, the USDOL was going to be less restrictive in terms of how specified your duties were, and there would be no cap on non-exempt work. Now, philosophically, what they're basically saying is that the statute was designed and intended to protect the little guy against big bad employers, because the statute was incepted out of a period in which there was a lot of little people that needed protection against, you know, people who had more influence and more power. And so hence the long test is it applies to people who make less, and the lower the amount of compensation that the individual receives, assuming it still meets the minimum standards, the department was basically signaling it was going to require more information from employers to ensure that that person who makes too little in the department's eyes really is an exempt level person and should not be entitled to overtime compensation. Whereas obviously the short test is saying, well, for those people that make a lot more than the average bear, we're going to be a little bit less inquisitive in terms of whether or not you should be entitled to overtime compensation. And again, those are philosophical underpinnings of the originations of the statute. And as we've progressed with the involvement of the statute, that sort of construct and those philosophies have kind of been blurred a little bit, and you'll start to see that in some of the later slides. So the last time we had a significant change to the FLSA was in 2004, and what happened was the Department of Labor basically ditched the long and short, bifurcation, and basically said, we're not going to just worry ourselves with the little guy anymore. We think all employees need to have the protection, a more discerned protection of the statute. And so even if you make $100,000 a year, we think we're going to look very critically at your employer's classification and in order to ensure that you are receiving all compensation that you are otherwise legally entitled to. So in 2004, that was a fairly significant shift in the philosophy of the FLSA. Then what happened was they implemented the standard duties test, and this actually makes sense, right? Because we no longer have this long and short dichotomy. We want to make sure that there are certain standards that in terms of duties that have to be established in order to demonstrate objectively that a person is properly classified as exempt under the statute. And so in 2004, they attempted to essentially create a construct as to what that should look like in terms of what duties really qualify for this exemption. We also, in 2004, experienced the minimum salary increase to $455 a week, which is the equivalent of $23,660 a year. Now, what does that mean? A minimum salary. What that basically means under the statute in lay terms is that anyone, as of this moment in time, as the FLSA is currently applied, anyone making $23,659 a year or less for a full-time level position or its equivalent, that person is presumptively entitled to overtime compensation. So, if you make $23,559 a year and you are the manager of a major business unit for a Fortune 100 and they're paying you as an exempt person because you have all these great significant responsibilities that are material to the outcome of the organization, then you are still legally entitled to overtime compensation even though you've got this amazingly important job. So it doesn't matter that you would otherwise meet one of the exemption classifications. You're not paid enough, so therefore you're entitled to overtime. So the next element that is important, and again this goes hand in hand with the philosophy of no longer being overly concerned with the little guy, is in 2004 we created the highly compensated employee exemption. So at that time, it was, I think, $106,000. So anyone making above the $100,000 level was now considered what we call an HCE, and so the department was basically saying, well, if you're making six figures, we're not going to be overly concerned with whether or not you're entitled to overtime compensation because in general, you're probably going to be what we call an HCE. But the converse of that means that anyone making less than six figures may presumptively be entitled to overtime compensation because they are not an HCE, and therefore even if you're making $99,000 a year and not otherwise fitting into one of the white-collar exemption categories, then you are entitled to overtime compensation is really what they were saying. The unique thing about what they also did in 2004, and this is actually relevant today, particularly for those of us who are really trying to struggle with how do we ready our businesses for the change that's about to take place, they did give us some samples of positions that they presumptively believed to be non-exempt or exempt. And some of the classic ones that they offered up were things like bookkeepers and, believe it or not, paralegals. Paralegals who are performing in a purely paralegal function are by definition a non-exempt individual. And this will resonate as we go through further slides, but the reason for bookkeepers and paralegals being presumptively an example of individuals that are entitled to overtime compensation is that neither one of them can perform their jobs without significant oversight and direction. The bookkeeper ostensibly from a CPA or a certified accountant, or the paralegal obviously without advice and direction and oversight from a licensed attorney. Otherwise, they'd be engaging in the unauthorized practice of law. So, so the statute, tried to help us out and give us a little bit more guidance around that. So, we then entered what are these exemptions? What are the white-collar exemptions? Well, in 2004, we put a little bit more structure around what that looked like, and we created the, executive exemption was already in place, but the elements for meeting the qualifications, in other words, when you hire an employee at the point of hire, we as employers are supposed to first and foremost think about, gee, how am I going to classify this person for FLSA purposes? Now, again, when you deal with the demographic of clients that I deal with, I fully well recognize that that not all of us do that. It's not on our frontal lobe. We don't immediately think about, oh, am I going to call them exempt or non-exempt? And we oftentimes just say everyone's salaried because we just speak in terms of salary, which again is just something that's very normal, but it's not very consistent with what the FLSA expects from us. At the point of hire, in theory, we're supposed to ask ourselves, okay, is this person eligible for an exemption? If so, which exemption are they eligible for? If it's an executive exemption, then we have to satisfy ourselves in writing, if not solely in thinking, am I going to pay this person on a salary basis? And remember, we talked about what a salary basis is. That means that I get paid the same thing no matter how many hours I work. And so that's the salary basis. And am I going to pay this person more than $23,660 a year? And okay, so great, if I meet those two things, then I have to ask myself, well, what are the duties that I'm going to have this person take over? And in order to meet the executive exemption duties test, you need to be able to establish that the individual is a manager of an enterprise or a significant department or division, okay? So these are high-level directorial positions that are responsible for entire departments of people, okay? It's not just, oh, I'm the clerk in the photocopy room and I have a team of people that photocopy underneath me. That would not be an executive exemption type analysis. This person also has to customarily and regularly direct 2 FTEs or their equivalent. So what does that mean? That means that as a executive, one of my primary duties is that I manage at least 2 FTEs or 4 PTEs, right, the half-time PTEs, or any combination thereof, but it has to be at least 2, the equivalent of 2 FTEs. And I must have the authority to fire and hire, or my suggestions are given particular weight. Now, this is really pretty critical because it's not just that, oh, the boss is going to ask me whether I think John Smith is good. The boss is going to recognize that when I say John Smith needs to be terminated and I'm terminating him this Friday, the boss is going to not stand in my way, right? Because it's my department, it's my division, and while there certainly are, bosses always can override us on virtually anything, the point of this clause is to establish that you really don't have to do a mother may I, that you're basically informing leadership that you've made a decision that this person needs to be either hired or fired, and that you're making that decision and you're going to implement it. So it really is, the executive exemption position is really intended to be very narrowly focused to very mid to senior level and executive level authority. And even that mid-level authority probably isn't going to make it, to the extent that that mid-level manager doesn't have the autonomous authority to make significant decisions with respect to hiring, firing, compensation, things like that. So relatively few people are going to fit under the executive exemption if the analysis is done correctly. So our other option is to consider administrative exemption. And this is, I will tell you, where 99% of my clients, they hear administrative and they say, yes, score, that's my exemption. I'm going to use that one. And this is not surprisingly also the exemption that gets most misused or abused if you're asking a Department of Labor regulator, and I do mean that by both federal and state standards. So the government, the USDOL, guesstimates that upwards of 86% of us are misclassifying our employees, and we're largely misclassifying them relying on this exemption. So what is the administrative exemption? Again, the individual needs to be paid on a salary basis, which means, again, that I get the same amount no matter how many hours I work. I have to meet that minimum salary, again, of $455 a week or $23,660 a year. And my primary duties, and this is exactly why this gets so misinterpreted. My primary duties in general have to be office or non-manual work, right? So you're thinking in your head, great, that's my secretary, she's my administrative support, or he's my administrative support, and they do office or non-manual work. That's directly related to, the management or general business operations of the company. And you think, yeah, well, that's like my bookkeeper and my secretary and, all these kind of administrative roles, right? Not really, no. The other aspect of primary duty under the administrative aspect is that the individual in question simply must exercise discretion and independent judgment, and this is where it gets really kind of cloudy for most, with respect to matters of significance. So now you have to ask yourself, okay, well, that's great. I know my secretary does, non-manual work, and I know that my secretary is involved, her work is directly related to management of the business, because without her, my business doesn't operate because I can't function. But the question becomes, well, that's great, but is that individual that you're thinking should be exempt under this level, does that person have the ability to exercise discretion and independent judgment? In terms of what that looks like, we have to turn to the case law. What does the case law, because remember, statutes are just statutes, and until case law develops, we really don't know what they mean. So there's always legislative intent, but that's not always really helpful to us as business owners. So the meat on the bones of discretion and independent judgment has kind of basically grown to mean essentially that the person, again, doesn't have to do a mother may I, that they have independence and autonomy to make significant decisions or matters of significance. So what I often talk about when I'm doing a live presentation, and I know that it's very difficult to do it in these sorts of situations, is, there's a lot, this is where an analysis comes in play. There's a lot of gray, but there's also a lot of black and white. Matters of significance, the statute actually says that a matter of significance would be the authority to purchase a fleet of cars that would meet the element under the administrative exemption to evidence that the person both has discretion and independent judgment on a matter of significance. If they have the ability to, sign a contract or pull out a credit card and buy a fleet of cars, then they're probably going to meet the standard under the administrative exemption. If, however, the person only has the authority to order office supplies, that person is not going to meet the administrative exemption standard. How I try to encourage clients to think about this particular exemption, because again, it is the most misused or misapplied, is if you would allow the individual that you want to fit under this exemption to access your bank accounts and pay bills directly, if the person can sign contracts without doing a mother may I, and I mean contracts of probably, tens of thousands of dollars, not just a contract with FedEx. Some sort of major decision that they have the authority to sign contracts, that they have the authority to move money, that they have the authority to, you could also do kind of hire and fire here, or the ability to encourage the company to go in a new direction, that they actually have a material influence in the destiny of your business, then that's the kind of level that administrative exemption is looking for. And it's important that you draft their job description to evidence how their position is intended and designed and needed to be one in which the individual has the authority to exercise discretion, independent judgment, and that they do exercise that with respect to matters of significance. Again, there's lots of gray there, and without the ability to kind of engage in conversation, it's a little bit difficult to talk more than just in general about recognizing really the burden is on us to establish the significant importance of that person's role. And then we have the professional exemption, and again, these are all the white-collar exemptions. And under the professional exemption, again, paid on a salary basis, minimum salary, but this one gets a little bit different, and this is where a lot of your people can be placed if they have advanced degrees, if they are technical professionals, and if they're, basically a person from a learned professional to a creative professional to a lawyer, teacher, etc. Now, where people misapply this exemption is oftentimes, for example, I'm a lawyer, but if I came to work for you as a biz dev gal, and yeah, my legal skills are really great because I can write contracts and I can do all kinds of this other stuff in addition to business development, but you really hired me as a biz dev person. You couldn't exempt me under the professional exemption because I'm not operating for you as a lawyer. I'm operating for you primarily as a biz dev person. So you have to be really consistent with your application or your invocation of the professional exemption, because you want to make sure that if you're going to rely on the fact that I have an advanced degree or I'm certificated, that my role with you needs to be related to that certification or that education. The other area where people oftentimes get a little far afield is with computer professionals. People tend to think, oh yeah, my web guy, my web developer guy, he's a computer professional, so I don't have to, he falls under this professional exemption. And again, that's going to be not the case. Under computer professionals, these are really kind of the advanced technical techniques. These are people who write code. These are people who design stuff. These are people who create organic content for your business, whether you have a interface that needs a special structure so that your business platform is unique from your competitors. That sort of computer professional is the kind of person that you're going to be relying on, somebody who can create organic computer options for your organization. That level individual is going to be exempt, but your web design person simply is not going to be. Think of the computer professionals, and this helps some clients think through this. It's like the creative professional. And the creative professional, you only get that exemption if you've got creatives on your staff, and these are people who truly create art and create some sort of, I'm thinking of like the funnies, you know, some sort of cartoons or something like that. Creative professionals are people who truly create something that's completely organic, that hasn't been created before, and those sorts of individuals then fall under the creative professional. Computer professionals are like that. They have to be creators in order to receive that exemption for the most part. And then we also have the outside sales exemption. And, you know, this is also important for people to recognize. I think sometimes people think, well, that person's a salesperson, so, you know, they're exempt from the FLSA. And again, that's not true. You have to segregate your outside sales from your inside sales. So although there's no salary requirement for a salesperson, because the statute recognizes that a lot of salespeople prefer to be paid on a commission-based structure. There are primary duties, and that obviously involves making sales and obtaining orders and contracts for services of use in facilities, but the person has to do this, you know, away from your place of business. They truly have to be an outside salesperson. So these people are out there in their cars all day. They work from their home office. They don't really come into the office. They don't have a regular place that they work with you. You basically just tell them, look, I need you to sell X widgets, and they go find ways to sell X widgets. Those will be your outside salespeople, and those will meet meet the exemption classification as long as they're primarily engaged in sales. But your inside salespeople, your people that, you know, are internal to the organization, and that, you know, think of your call centers and things like that, those individuals are not going to fit into the construct of the outside salesperson at all, and those people are certainly going to be eligible for overtime compensation unless you can find a way to properly classify them into one of the other exemptions about which we've already spoken. The final exemption, we've already kind of touched on this, is the HCE, the highly compensated employee. And again, you'll remember that the regs from 2004 created this classification, and they set it at the six-figure benchmark, and this is in existence today. And as I already said, what it basically means is that anyone up to $99,999 can still very, very easily be determined to be eligible for overtime compensation. And, you know, they were essentially just setting this $100,000 collar, if you will, to kind of signal that if you're probably making six figures, then you're probably not entitled to overtime compensation. That's not to say that you aren't, like as in a black line, black letter rule. It's just that they were signaling that it's probably not going to be the case that you're entitled to overtime. And to be an HCE, you regularly have to perform the functions of one of the categories that we've already talked about under executive, administrative, or professional. So again, the presumption there is when you're making that much money, you probably do have independence, autonomy, you probably manage people, you probably have the ability to influence matters of significance, including hiring and firing and promotions and things like that. And so that's the HCE classification. So what are we looking at coming at us? And, let's just kind of walk through this a little bit. The new rule, which, I don't think I need to go through the legislative road that this undertook, but it's been coming at us for about 18 months now. The DOL announced it 18, 20 months ago that it was time for us to focus on bringing the FLSA kind of up to speed with today's current reality. And then there had to be the regulatory process, the administrative procedure that needed to follow, including notice of rulemaking and all of that stuff. Now, the Department of Labor under President Obama has been one of the most liberal and one of the most aggressive departments of labor, and frankly, I think it's no surprise that this began 18, 20 months ago, because they recognized that this was going to be the last chance opportunity, frankly, to try to get something this monumental through. Originally, when they first announced it, they were looking for an even higher new minimum salary requirement than what we ended up with. So I guess there's reasons to be happy based on that. But The reality is that they ended up finally issuing the new rule where they said that the new minimum salary requirement is $913 a week, which is basically $47,476 a year. So again, and we've talked about this, what does that mean? That means that anyone making $47,475 a year or less is presumptively entitled to overtime compensation effective December 1st. So they also looked, when they did this update and revision to the Act, they looked at the duties test, and there was some talk about changing the standard duties test in various ways, but for the most part, they left that alone. But they did increase the HCE salary requirement, the highly compensated employee, from 100 grand to 134 grand. So again, what that means is presumptively anyone making $134,003 a year or less may be entitled to overtime compensation once the rule takes effect, which is December 1st. I just want to note for you guys that they didn't pull these numbers out of thin air. There was an analysis behind them, and for those of you that really want to get down and dirty, it's kind of fascinating how they went about it. But essentially, they set the threshold at the 90th percentile for full-time salaried workers nationally. They also indexed it so that the statute now, whereas before, recognize we didn't touch the statute since 2004, now every 3 years the statute will automatically kind of go through a revivification, which basically means that they will look to see if the $47,476 is appropriate 3 years from now, and they will determine whether or not it's appropriate based on the 40th percentile of full-time salaried workers working in the lowest wage census region, which I don't remember the exact county, but it's like it's a county, I want to say, in Missouri. So so that's important to know. Because that's going to affect how you approach your policies, right? You're going to have to recognize that this is going to automatically need to be addressed or revived or edited on a 3-year basis. So those are the more significant aspects or the key provisions of the new rule. One of the things that I wanted to drop a footnote on for all of you guys on this is the importance of understanding how you compensate your people. Too often in my experience with clients, you know, a lot of us bonus our employees, and most of us bonus in a discretionary manner. The thing about bonuses are that it can definitely affect, for those individuals that are entitled to overtime compensation, how you bonus an individual can affect what sort of overtime compensation they're entitled to. So with respect to non-discretionary bonuses, non-discretionary bonuses can be used to help satisfy the salary level, right? So because these are non-discretionary, these are things that you say you will get this bonus every 3 months or something, and it's not contingent upon something necessarily. So when you structure compensation in that way, which I don't think too many employers do, but some do, then you can count that towards meeting the standard salary level. You can also use incentive payments and commissions to satisfy a certain percentage. I think it's 10% of the minimum salary requirements for the white-collar exemptions, right? So remembering for your internal salespeople, right, who are otherwise overtime eligible, you'll want to consider whether or not how their commission-based structure may or may not satisfy meeting minimum salary requirements. And then there's an opportunity to use catch-up payments at the end of quarters in order to apply for the minimum salary or help to meet or exceed the minimum salary requirements. So there are options available to us in terms of how we compensate our employees in order for us to establish that we've met certain of these minimum salary standards. Under the new rule, it's important to recognize, remember I mentioned that 20% element that used to be kind of the standard. Under the new rule, they're now applying a division of labor test. So essentially the statute or the department is still recognizing that many of us have individuals that kind of have a blended role. And you know, maybe I am both a waitress in a restaurant and the manager of the waitressing team, right? So then the question becomes, well, am I exempt or am I not exempt because I'm both a waitress and I'm the manager? And the department is giving us guidance under these new rules that basically says that if the employee spends 50% of his or her hours performing any one of the white-collar exemption standards of duties, and then you probably can classify them as exempt. But if the manager spends, you know, they use as an example 25% of the time in doing administrative or executive duties or professional duties, then that person is going to be, no matter what, that person is entitled to overtime compensation, even though they have the ability to hire and fire and make important decisions on behalf of the organization. So what's the impact of, those are the key new provisions. What's the impact on this? And these are the Department of Labor's own statistics, right? So I would imagine that they're fairly conservative. When I talk with people, no one's really surprised by these figures, but it really is a tectonic shift in terms of how we're going to be compensating the vast amount of the American workforce. So the Department of Labor estimates that there's, that this rule change is going to affect 4.6 million current exempt workers. So that's a lot of people, and that means a lot of us really need to be looking at how we've classified and how we're compensating people today, because in all likelihood we're impacted by this rule. 6.3 million white-collar currently exempt workers will essentially have their overtime protection strengthened, which is to say that there were a lot of people that were kind of in a bubble zone, and now those people are no longer going to be in a bubble zone. A lot of people here are like in the restaurant industry or in the retail industry are definitely in this second bullet. The cost to those of us who are employers are guesstimated to be about $1.8 billion in the first year alone. And as I already indicated, we know that the hardest hit are going to be kind of retail shops, restaurants, nonprofits, small businesses, and call centers. We need to recognize that that the new minimum salary requirement has been increased pretty dramatically, and figure out how we're going to handle that for ourselves. So some of this, there's different options based on your risk profile, right? As I indicated earlier, I do have clients that say to me, I know that the regulation says this, but I simply can't afford to be in business if it says this, and I can't do that. And then it's a question, as long as it's not criminal, right? It's a question of, well, what's your risk profile and how do you devise a strategy to mitigate your risk while recognizing the reality of that risk. So one of the first things that I think it's critical for all of us to be doing is we need to just first and foremost pull payroll records and assess our current workforce composition. And one of the quickest and easiest ways to do that is pull the salary records or the payroll records and identify who's making less than the identified new minimum. And then really kind of focusing pretty aggressively in on anyone who falls below that standard, and then taking a look at what their job duties are, right? All of this is going to require at some level, and I know that no one really wants to hear this, but all of us need to go back and look at our job descriptions in light of when you pull your salary records to figure out how you will be impacted. I don't think it's a question of if, but most every one of my clients is going to be impacted. I think I have one client that's not going to be impacted. So pulling your payroll data records, looking at anyone that falls below that line, then critically and carefully looking at their job description to figure out, is there a way to create a exemption where they're doing at least 50% of one of the white-collar exemptions work? If so, does your job description adequately reflect that reality or not? And then assess whether or not, maybe you probably hadn't even classified the person correctly to begin with, and how do you reclassify them without potentially opening yourself up to liability, going backwards. So asking yourself all those questions to really understand the impact to your budget, because as business owners, ultimately, we just really need to understand, what does this mean to my bottom line, and how am I going to deal with that reality? And the only way to figure that out is to at least start with, looking at who falls below the line. That's not to say that you shouldn't look at people who fall above the line, because I'm venturing a guess that many of them may be misclassified as well, but at least starting by looking at who's falling below the line and what that immediate impact is going to be. So then obviously, quantifying your risk and understanding that, the more non-exempt employees you have, then the potential for increased payroll costs is a reality. But never forgetting that we always have the right to control overtime hours, and making sure that your employee handbook properly reflects that right is going to be critical as well. I mentioned very early on about the significance of timekeeping and time tracking. The Division of Labor test requires that we as business owners, the burden's on us. So what does this mean? I've got a client that said to me, Victoria, I really don't want to treat my people like they work at McDonald's, and we don't make people clock in and out, and we don't make them record their time, and in general, we just kind of have them submit their time, and they always submit 8 hours a day. And I say to them, look, I recognize that there's an organic cultural reaction to being told that you're now a non-exempt individual. Now, there's definitely a psychology to that. I don't personally understand it, but there is a psychology. And you as business owners, for people who are going to be impacted, I would encourage you to recognize that a lot of people aren't going to like being told that, but finding a way to communicate, why you need to change their classification and what that means for them in terms of compensation, if anything, is going to be very important. So recognizing your timekeeping requirements is really important. Now, that doesn't mean that you have to put the clock on the wall and make me clock in and out, but it also means that you should be very cautious about just telling people to fill out timesheets with 88888 on it, because the Department of Labor most certainly is going to assume that that's just a ruse if you ever should get audited. So you really need to find a way to record time that comports with your internal reality, your culture, your ethos, but recognizing that the burden is going to be on you to demonstrate that if you fire me a year from now and I go to the Department of Labor, by which I mean probably the State Department of Labor, and I say, I was fired from ABC Company and I've worked there for a year, and I worked oodles of overtime hours. I mean, every week I worked 10 hours of overtime, but they made us complete our cards with 8 hours a day. The Department of Labor is going to trigger an audit, and if everyone's cards really do just say 88888, they're probably going to believe me in telling them that I'm entitled to overtime compensation for 10 hours for every week, every one of the last 52 weeks, and now you're looking at a liability, not only for me, but frankly, they'll audit everyone, and they'll say that anyone that they think is eligible for overtime compensation should have been given it, and we don't believe your records because they all say 8 hours a day. So it's these sorts of things that we really need to recognize that, again, it's all about a matter of risk profile, but it's also a matter of understanding how we manage people and how the regulators will look at us should an opportunity for an audit present itself. So in addition to making sure that you have a timekeeping or a time tracking methodology in place, reviewing and updating your employee handbooks is going to be absolutely critical, as is reviewing and updating your job descriptions. And I truly cannot emphasize that more, because that's the first thing that the regulators are going to look at if you should be caught in a audit type situation. So what options do we as employers have at this point? So first, obviously, you need to figure out, what does this mean to me? How is it going to impact me? What's my risk, and what am I willing to do about that? Well, what are you willing to do about that depends on what sort of options you have available to you. You can always increase your salary to meet the new minimum, but require more in terms of hours and productivity, right? So, we could do that. I'm not so sure that that's the best solution for most of us, because you're basically just increasing your cost, and you aren't necessarily knowingly or prophylactically ensuring that I'm still meeting the new standards. So you could actually be inadvertently increasing your risk if you just kind of approach it with a very simplistic solution. You could convert currently salaried individuals to an hourly basis and pay the anticipated overtime. That's equivalent to the former salary. You could do that. You could treat as overtime eligible and continue to pay on a salary basis, which is basically, you pay me my current salary, but now there's always, you can always convert a salary to an hourly basis, and then I'm eligible for overtime on that hourly basis. But in doing that, and again, we're, as business owners, as managers, we always have the ability to manage overtime. So in managing overtime, you need to make sure that your employee handbook says very crystally clear that you may not work overtime without, written approval from your direct manager or something like that. But recognize, if you choose this approach, you need to make sure your line management knows about their obligation to not turn a blind eye to the fact that I'm, answering emails on the weekends and doing all this stuff from a cell phone owned by the company, which, by the way, raises a whole other issue for those of you who do have people with who are sending emails on the weekend, who have a company issued cell phone, who are online after hours. You're really going to have to communicate around how you really don't want them to be doing that. And when you do receive emails after hours from those individuals and you do not want to be paying them overtime compensation, it's incumbent upon us as business owners to say to them, I asked you not to work outside of regular business hours. Thank you for this note, but in the future, please just communicate with me during regular business hours. And I know that that's going to be hard for a lot of us, including me, but if your desire is to manage to your overtime, that is a message that you're going to have to send, and it's a message that you're going to have to demonstrate to the regulators that you did send in order to protect yourself against future claims of overtime compensation. Real interesting footnote there. I don't know how many of you guys are aware, but France, fairly recently, I'd say in the last 2.5, 3 months, actually passed a national law that people are absolutely prohibited from working after hours and on weekends. So that's actually become a law in France, and I think the City of London just passed something similar. So all of this is starting to come around full circle, and I would guesstimate that we might see California, because, in America, things always go the way of California in the area of employment and labor law. I would imagine we're going to start to see something like that coming out of California in the not too distant future, which means it's probably coming out to the rest of us. Another really interesting option for people to consider is what's called the fluctuating workweek method. Now, this is a very high-level summary of it, and it's a lot more complicated than this, but basically, an option for some of us to consider is what we call the FWW method, to pay reduced overtime premiums. What this is basically, you recognize that I'm overtime eligible, right? But you pay me on a salary basis. And it can be below the minimum, right? But it has to meet the following requirements. The employee has to be paid on a fixed salary, right? And so you could pay me a certain amount of money, and you could say, Victoria, we guesstimate that you're going to work approximately 30 hours a week. But we know that there's going to be weeks where you work 40, but we also know there's going to be weeks when you work 30. So, but we're going to put you on this fluctuating work week method because we know that your hours can vary greatly. And if you're okay with accepting a pay that's based on 30 hours a week, recognizing there'll be days when you'd have to do 40 and 20, it all works out in the wash. And if you're okay with that, that's how we're going to pay you. And I say, great. My salary still has to be set above the minimum wage, and there has to be an understanding about the hours worked, but they can fluctuate. And what happens under this method is something really kind of unique, and that is that instead of paying me, if there's a work week, and here's a little example. If there's a work week when I'm that person and I actually work more than 40 hours a week, because remember, the FLSA requires that if I work more than 40, I'm entitled to overtime compensation. Instead of paying me, let's say I work 50 hours, instead of paying me 10 hours at time and a half, you only have to pay me 10 hours at half of my base salary. So what it does is it allows you to recognize that there's times when I'm going to require overtime compensation, or you're going to require me to work overtime, but you're anticipating that I'm not going to have to pay. You're recognizing that you're not going to pay me at 1.5 my base salary. You're only going to pay me at half my base salary, and it's a really solid way of mitigating your liability, and it's a perfectly valid way to do it. Now, the thing to be careful of here is I would discourage you from, hiring me and saying I'm going to work 38 hours a week under the fluctuating work week methodology, because that really looks like a ruse. But if you're kind of in that 25 to 30, maybe even 32 hours, and you can feel comfortable that you're going to hire that person at that, recognizing that they're going to fluctuate, this may be a really viable option for you in terms of managing to that condition. So in conclusion, really the question is your organization ready? How ready are you? Recognize the impact is going to be really pretty significant. The salary increases is pretty impressive. The automatic increases to the salary basis needs to be considered. So recognizing that every 3 years there's going to be an automatic review of that is going to be really important. To the extent that you guys have HCEs within your workforce demographic, recognize that their job descriptions need to be drafted in such a way as to ensure that that classification is appropriate. And please, please, please recognize your state laws can have a direct impact on how you approach evaluating your risk. And recognize that having flexibility within the workplace, there's going to be an inherent tension, right? Because if you've got a whole lot of flexibility built into your workforce in terms of capturing time after hours and things like that, that may inadvertently increase your risk. So managing that in a way that's appropriate for your culture is going to be really important. Then finally, consider the duties test and the non-discretionary bonuses, because there is a definite impact on non-discretionary bonuses with your ability to meet the minimum wage. And there's also similarly an impact on discretionary bonuses in terms of how that might impact your overtime obligations. So with that, I am happy to take questions if we have any.
All right, thank you, Victoria. And sorry everyone that we're running just a little bit over time, but we do have some, no pun intended there, by the way. We do have some questions. So the first one is, how do you handle out-of-town travel?
Wow, that's a really good one. Okay. The FLSA goes through great lengths to talk about overtime and how it applies to travel, and at a very high level, because honestly this is a analysis in and of itself. So at a very high level, the FLSA basically says if I'm forced to drive outside of basically the demographic, like the Denver metro area, if you ask me to go do an overnight in Cheyenne, Wyoming, and I can only get to Cheyenne, Wyoming by driving, I am unable to do anything else between Denver and Cheyenne, and therefore all of that is compensable time. So what you'll want to do as an employer is to not necessarily make me work from 8 to 5 today and send me tonight to Cheyenne, Wyoming, because now you've opened me up to overtime compensation because I have to drive my car. But, and then again, we're only talking non-exempt individuals, not salaried individuals. But if you want me to go to Missoula, Montana, and I'm going to take an aircraft to there, then you can ask me to work from 8 to 5 and jump a 6 o'clock flight. Why? Because I can do whatever I want on the airplane. I can, read a comic book and I can read a novel, and I don't have to work. I'm not being made to suffer work, which is the key terminology under the FLSA. So with respect to travel outside of one's metropolitan area, you really have to kind of assess whether or not the person is being made to suffer work, i.e. by driving a vehicle and they have no other opportunity to do something else, or if they have an opportunity to do something else, then they probably aren't entitled to overtime compensation for those hours.
Okay, perfect. And what are the chances of this actually being repealed?
Yeah, pretty much no chance of that. The Obama administration's DOL timed this, I think, on purpose. They knew that the next president, whomever it would be, probably wasn't going to necessarily be a huge advocate of this kind of radical change. And so now was the time. And it's gotten through, and it's passed through the administrative procedure process, and there's just really, it's kind of like a snowball's chance in hell at this point that this thing gets repealed.
Okay, thank you. So I don't believe we have any more questions. Victoria, did you have a slide with the contact info for the AR group after this one? We can go ahead
I
and
think I do.
All right,
There you
perfect.
go.
Well, there's her contact info, so if you do have any questions, please feel free to use that. And you can check out all of our previous BOSS webinars on demand by visiting thealternativeboard.com and clicking on webinars. And you can also register for our upcoming session, which will be on the overarching financial topic. So thank you guys for joining us today, and we hope that you have a wonderful rest of your day.
Thank you.